Welcome to the Public Sector SCM and Procurement Collaboration Platform. My name is Sean Scott. I have an engineering background. I'm not a lawyer, and I mention that to you because I'm going to just be running through an important event that took place today in the public sector procurement space. Basically, the Constitutional Court of South Africa met today to consider a really important case around the Supreme Court of Appeal's decision last year in 2020 on the 2nd of November to declare that the Preferential Procurement Regulations 2017 are invalid. Now that order of invalidity was declared, was suspended rather for a period of 12 months, but it was appealed, and the Minister of Finance, who is responsible for the Preferential Procurement Regulations, appealed the decision of the Supreme Court of Appeal, and today, the 25th of May, that was heard by the Constitutional Court. So the purpose of this is really just to take you through some of the highlights. I'm not in a position to forecast or to tell you exactly what the Constitutional Court is going to decide, but there are a couple of really interesting points that came up which I'd like to share with you today. Essentially, this case was really brought about by an organization called Afri Business, a non-profit company that really disagreed with the whole substance of the 2017 Preferential Procurement Regulations. And the case was heard on the 8th of September 2020 and was decided on the 2nd of November. And that's when the decision came out. And this is really known as the Afri Business versus Minister of Finance case around the Preferential Procurement Regulations 2017. Two of the sections in the final judgment by the Supreme Court of Appeal, it follows, therefore, that the Minister's promulgation of Regulation 3B, 4, and 9 was unlawful. This was the conclusion of the Supreme Court of Appeal. He, the minister, acted outside his powers under Section 5 of the Framework Act. In exercising the powers to make the 2017 regulations, the minister had to comply with the Constitution and the Framework Act, which is the national legislation that was enacted to give effect to Section 217 of the Constitution. The framework providing for the evaluation of tenders provides firstly for the determination of the highest point scorer, and thereafter for consideration of objective criteria which may justify the award of a tender to a lower scorer. The framework does not allow for the preliminary disqualification of tenderers without any consideration of a tender as such. The minister cannot, through the medium of the impunged regulations, create a framework which contradicts the mandated framework of the Framework Act. That was Section 40 of the judgment, and 46 basically, counsel for the minister submitted that in the event that the court finds against the minister on the merits, it should consider setting aside Regulation 4 only and not the regulation in its entirety. However, that option, due to the interconnectedness of the regulations, may not be an appropriate one. It was further submitted that any order of invalidity should be suspended for a period of 12 months to allow the minister to remedy the defects. The appropriate remedy in the circumstances will be to declare the 2017 regulation to be inconsistent with Section 217 of the Constitution and Section 2 of the Framework Act, and suspend the order of invalidity for a period of 12 months from the date of order. So effectively, the Supreme Court of Appeal said that the 2017 regulations in its entirety are invalid, and that the minister really has 12 months to sort everything out, and hence said that the order of invalidity is suspended for 12 months, which brings us through to the 2nd of November 2021. Now, just to get going, there is a lot of discussion that will take place around Section 217 of the Constitution. Now, there are two slides I'm going to go through now. The first slide just gives Section 217.1, which basically heads up with the procurement heading, and then goes on to say that when an organ of state in the national, provincial, or local sphere of government, or any institution identified by national legislation, contracts for goods or services, it must do so in accordance with the system which is, and these are the 5 important words: fair, equitable, transparent, competitive, and cost effective. We're not going to spend a lot of time on this now, but suffices to say that this is a really important starting point to Section 217 of the Constitution. It goes on to subsection 2, which says that subsection 1 does not prevent the organs of state or institutions referred to in that subsection from implementing a procurement policy, providing for categories of preference in the allocation of contracts and the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. 217(3) goes on to say that national legislation must prescribe a framework within which the policy referred to in subsection 2 must be implemented. And just a little note from us to say that that must was previously a may, and so with the amendment which took place in 2001, it basically changed from may to must. So very important subsection 2 saying that despite subsection 1, it does not prevent the organ of state from or institutions referred to in that subsection from implementing a procurement policy, providing for categories of preference in the allocation of contracts and the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. So you'll hear throughout the summary that I'm going to go through now why this is very important in this particular case. So the Constitutional Court met today. It was a hearing of almost 2.5 hours, 5.5 hours, my apologies. And yes, a pretty full bench of 9 justices of the Constitutional Court were there, and heard submissions from, of course, the advocate who represented the Minister of Finance. There's another advocate as well who is responding to one of the applicants. I'll mention the applicant shortly. Of course, Agribusiness was represented as well. The EFF were also made a submission, as well as one of the applicants, which is an organization by the name of Fidelity Security Services, together with the industry body that they work with, was another organization that decided that they would also make a submission to the Constitutional Court, and that Fidelity submission will be discussed briefly towards the end of the Constitutional Court case. So let's get on to what the summary was that of each of the arguments that were made during the day. So the advocate who was representing the minister, in essence, said that the main thrust of their argument is in Section 5 of the PPPFA, or the Preferential Procurement Policy Framework Act. And basically, Section 5 talks about any matter that may be necessary or expedient to prescribe in order to achieve the objects of the Act. So basically saying that the Act says that the minister has got the power to create regulations such as the Regulation 4 and Regulation 9, which was specifically mentioned by the Supreme Court of Appeal as being invalid. And they basically argued that Section 5 basically gives the minister that power to really make that piece of legislation. The other, from my understanding, the other point that they made was just arguing the point that Section 1 of the Preferential Procurement Policy Framework Act talks about acceptable, and basically arguing that pre-qualification criteria, which is the one that is used in Regulation 4 and also Regulation 9, are accommodated under the Framework Act in Section 1 of the Act as an acceptable tender. And that was the second real thrust of their argument. So the first one was around Section 5, and the second one was around the definition of acceptable. There was a very, very interesting discussion that took place. Now, I was unable to get a copy of that particular discussion that took place, but I would refer you to the YouTube recording of the Constitutional Court, and particularly to the discussion that took place at 55 minutes into the recording. And what was really interesting there is that the justice referred to section 2.1, and there was a long discussion around this. And 2.1 basically says, it's actually repeated in two sections of the document, framework for implementation of the preferential procurement policy. 2.1 says, an organ of state must determine its preferential procurement policy and implement it within the following framework. So an organ of state must determine its preferential procurement policy and implement it within the following framework. And this was discussed at some length. And just a point for the SCM practitioners that we're working with is we're often talk about this in the different workshops that we run. And we're just pleased to see that the Constitutional Court had read this as well in that important context. In particular, the discussion then went on to say that that preferential procurement policy needs to consider 2.1D and 2.1E. And 2.1D, particularly 1, talks about the specific goals that may include contracting with persons or categories of persons historically disadvantaged by unfair discrimination on the basis of race, gender, or disability. It then goes on to make reference to the Reconstruction and Development Program. And 2.1E says any specific goal for which a point may be awarded must be clearly specified in the invitation to submit a tender. And there was quite a long discussion around this. I just want to share with you a little bit of towards the end of that discussion. And you might also just get a little bit of a sense of the vibe between the 9 justices and the advocate that represented the Minister of Finance in this little short extract.
And the implementation of that policy. It doesn't mean that when it comes to those who were previously disadvantaged, suddenly the requirements of section 2171 are irrelevant. They're still relevant.
Justice Jafta, I'm indebted to you twice. that is correct. So the argument I made earlier about exception applies to the determination stage, but the implementation stage, and we have made the submission, and the High Court makes the finding that once you have determined the policy, when you implement the policy, everyone must compete transparently, cost effectively. All of those factors come into play. That is the proper framework to look at the issue, Justice Jafta. I'm indebted to you.
That was one of the points that that came up, is just around that. And there's a little bit of a discussion that happens towards the end of the case as well around these categories of preference. I don't have much to talk about in response to regarding Advocate Mkululi Stubbs, who dealt with the submission by Fidelity, also representing the minister. But I thought that he was extremely eloquent, and there he basically very effectively dealt with the Fidelity application. And he has a little snippet about from Advocate Stubbs and one of the points that he deals with on the Fidelity application.
And if that's the case, then the minister needs, if prayer 6 is to be granted, to be given an order to exercise his executive discretion to direct other organs of state to not apply a law. Now, putting it in that way, we respectfully submit, justices, demonstrates the clear non-joinder that the applicants have made themselves guilty of. If we are speaking about an order from this court that is intended to have an impact on organs of state, what do the organs of state have to say about that prospective order? Well, the answer is that they have nothing to say because the applicants have not cited them as parties to the application. So the applicants have effectively engineered something of an ex parte situation where they want organs of state to be bound by relief that's sought, but where those organs of state have no say in whether or not that relief is granted.
You could see there that Justice Madlanga was actually agreeing with, his body language was showing that he was agreeing with a lot of what Advocate Stubbs was saying. There was a discussion by the EFF on their submission, which my understanding was it was fairly similar to the arguments that were put forward by the Minister of Finance, really around Section 5. There wasn't much engagement with the advocate. There was a small engagement, and here is the summary.
So again, being very careful, I'm not suggesting for a minute that the minister can go over and above what is provided for in the Act. All I simply am saying is that it can cover individuals provided they suffer unfair discrimination and they fall within the framework of 2.1.
So it is referring to the words may include in D, and which generally anticipates but not limited to. Is that the basis on what you're saying, that Section 2 is not limiting?
That is my submission, Justice Bennett.
Thank you.
And that really was the only real discussion that happened on the EFF submission. For the respondent, Afri-Business, Senior Counsel Bergen-Thien presented arguments, the arguments which were presented to the Supreme Court of Appeal, which was really that the regulations, particularly regulations 4 and 9 around pre-qualification, were not catered for within the framework of the Act. Now, there were a number of interesting discussion points that happened. And the first discussion point that I thought was really interesting was around Section 2172 of the Constitution. Let's have a listen to what was discussed here.
The product of that. How to be able to anticipate what the Act should provide for and what it should not provide for. We must look at the source being the Constitution. So it is on that basis that I want us to focus at the Constitution now, because that is what is going to tell us what the Act must provide.
Yes.
Coming back to the Constitution, would pre-qualification fall within the ambit of open quote, categories of preference, close quote, or not?
Yes, well, I must concede it must fall within pre-qualification, must fall within categories of preference in the allocation of contracts. So that is allowed in terms of 2171(2)(b), that there may be categories of preference in the allocation of contracts. But then we must further have regard to the Procurement Act with respect, Justice Madlanga.
I don't understand that.
No,
I don't understand that. I'm repeating myself, and I say again, it's a standing constitutional principle that you cannot use an act of parliament to interpret the Constitution. And I'm still focusing at the Constitution. So I do not see why, when we are still at that level, you keep drawing me to the Act of Parliament. In fact, this is not something new. It's not just about the constitutional interpretation. Even with regard to ordinary acts of parliament, you cannot, for example, use regulations made in terms of an act of parliament to interpret the act of parliament. So its basis is not a new principle. Now, if in terms of Section 2172, the idea is to protect or advance persons or categories of persons disadvantaged by unfair discrimination. And this provision is prefaced with the words, subsection 1 does not prevent organs of state from creating these categories of preference. Does it not make nonsense of what this subsection, that is subsection 2, seeks to achieve, to then subject it to the very subsection that it says, it being subsection 2, it says, whatever subsections 1 may be saying, organs of state, you are free to create categories of preference in order to protect or advance previously disadvantaged persons. Does it not make nonsense of that to then subject that very provision to subsection 1?
Maybe I can explain it like this.
It was really interesting. So getting down to concluding, and senior counsel conceded this, that subsection, that 2172 does allow for pre-qualification at a constitutional level. It does allow for pre-qualification and categories of preference. Really, really interesting, and very, very interesting as well, just from a legal perspective, to say that you don't use an act or a regulation to interpret the Constitution. You must be focused on interpreting the Constitution and the essence of the Constitution, and not try and use an act or a regulation to try and do that, which is what often happened during the arguments of Agribusiness Senior Counsel. So that was the first one. The second one was, there was a real interesting discussion around specific goals. And here in particular, Justice Jafta had a discussion then with the senior counsel for Agribusiness.
Let's look at section 2(1)(d).
That's of the Act.
Do you accept that it permits the inclusion in the procurement policy of unidentified specific goals?
D, which specifies the specific goals may include.
Yeah.
Yes. That specific goals refer back to the specific goals which we find in B sub 1 and sub 2, where reference is made that for contracts with a rand value above the prescribed amount, a maximum of 10 points may be allocated for specific goals as contemplated in paragraph D.
As that is the part of the Act which makes it clear that specific goals may be made upfront, mentioned upfront. It says in the tender documents. Now, why should the same goals not be mentioned in the policy? For them only to say, in terms of the Act, it is only permissible for them to be mentioned in the tender documents. If you mention them in the policy, you're acting contrary to the Act. But if you mention them in the tender documents themselves, then you comply with the Act.
Interesting.
No, surely specific goals may be mentioned in the policy. But
they may be mentioned.
Yes, but the important aspect, my Justice Jafta, is that specific goals are limited in terms of 1B with a specific cross-reference to 2D that only 10 or 20 points may be allowed for specific goals. So it cannot be argued that specific goals may first serve as qualification criteria, and thereafter again 10 or 10 points may be allocated for specific goals, because the first requirement is that an organ of state must determine in its procurement policy and implement the following framework. A preference point system must be followed.
What you are saying actually speaks to the implementation. It doesn't speak to the determination of the policy. And I understand your concession to be that specific goals may be included in the policy. So there's nothing in the Framework Act which prohibits the mentioning of specific goals upfront in the policy. They may be mentioned, but what you are saying is that once you have done that, when you are implementing the tender, evaluating the tenders, for those specific goals, you can't award more than 20 points. That's a different point. The issue that we were dealing with is whether or not the minister had power to make regulations which allow the mentioning of specific goals in the policy.
Interesting discussion there around specific goals. And yeah, that's certainly one that we were going to look at with interest when the Supreme Court, the Constitutional Court eventually comes back with its decision. Just to recognize Mark Oppenheimer, I wasn't 100% sure who he was representing. There wasn't much discussion around the case he was making. I did see some of the commentary to say that he was making some good points, but I really missed the key differentiators of the points that he was making. But just to mention that he did also make representation. Then the applicant's Fidelity Security Group, represented by Advocate van Zyl, basically was saying that the supplier, in this case Fidelity Service, had suffered as a result of the decision by the Supreme Court of Appeal, and so have many others in the industry. And but there was a really interesting discussion that then took place around competition in Section 2171 and categories of preference. So how categories of preference are applied within Section 2171. Categories of preference are mentioned in Section in 2172, and how they are applied in 2171. Have a listen to this little discussion around competition, categories of preference, and Section 2171.
Section 2171 say competitiveness only means when there's going to be a big group.
No, it does most certainly does not.
So
but
why do we link,
why
do we link competitiveness to a small to a big group?
Justice, I would necessarily say that if you compete with a smaller group, it takes away competitiveness. When there's a larger group and people that are functionally better to apply for these tenders, then there's a competitiveness that would actually say that would actually meet this requirement.
But the Constitution doesn't say so. We heard over and over again things like, because the Constitution doesn't say you must give an exclusion in advance. It doesn't say you must give an advantage or preference to Black people and so on. We have, but I'm asking now because the language of the Constitution doesn't say that. Once there has been a limitation to a group of previously disadvantaged persons, there cannot be competitiveness within that group. It doesn't say so. So you can still apply section 2171 within that group, because 2 says what 1 requires does not prevent you from protecting and advancing those who were previously disadvantaged. So we know that we have to read 2171 and 2172 together and try to create harmony between the 2 sections. The second one intends protection and advancement of those who were previously disadvantaged, and it says you can have categories of preference of those people. So I don't understand the argument that says, oh, no, because now you could have had a bigger group of competitiveness. It's no longer competitiveness if it is within a smaller group, and therefore section 2171 is not complied with. I have difficulty with that.
So that was a really interesting little discussion there to say that if you have categories of preference, if you have a category of people, that you can still apply section 2171 being fair, equitable, transparent, competitive, and cost effective within that category of people. And that was a really interesting little discussion that they had there. So just in closing then, the closing arguments then from the advocate who represented the Minister of Finance, just talking about the categories point that was just made, as well as a little bit of a conclusion around the use of targeting and the word called set-asides.
The first point I want to address is that from the debates between council and the bench, it's become crystal clear that the categories of preference, which may be based on previous disadvantage, are permitted by section 2172A and B of the Constitution. Secondly, that section 2D of the Framework Act permit organs of state in the determination of their preferential procurement policy to adopt such categories of preference. That is not inconsistent with section 2 of the Framework Act. And thirdly, that the categories of preference can permissibly target specific groups within the previously disadvantaged group. And we have referred in that regard to the judgment of Barnard, where we refer to the majority judgment as well as the judgment of Justices Cameron, Froneman, and Majid, which makes it clear that our Constitution permits such the targeting of restitutionary measures against those categories of people. And the suggestion that it is unconstitutional to do so because our Constitution is based on non-racialism is to ignore the fact that the pernicious effects of apartheid, which are referred to in Viking, were based specifically on race. And as the minority judgment says in Barnard, you've got to reverse that disadvantage. You have to reverse it based on race, fire with fire, but with a long-term objective of achieving an equal society. But that unless you do so, you're not going to achieve that equal society. The second point.
There was just some points then from the Minister of Finance. So that really, in summary, was a couple of the key points that came through. The Acting Deputy Chief Justice concluded by stating that the judgment is reserved. And so we will certainly look forward to hearing when they will make a decision on this one. We do know that the Constitutional Court is extremely busy and they've got lots of decisions to make. So this is one of those. I don't think that it is necessarily going to be a very difficult decision for them to make. Would be surprised if it is not a unanimous judgment. I didn't see anyone really arguing against any of the discussions that particularly Justice Matlanga and Jafta were making throughout this discussion. And yeah, it'd be really interesting to see what happens. And if you've got any more questions around this one, please feel free to contact my business partner, Henry Carlser at will.co.za, henry.carlser@will.co.za, and myself, Sean.Scott at will.co.za. Will is 1L, wil.co.za.